A very good day, Miss Young.
My name is Samuel, the Lion of Fairness.
I am Baby George, the baby of justice.
My name is John the police.
My name is Justin, the monkey prof in law.
My name is Jan the Good.
Today, we are going to present about 3 cases which are related to the application of common law and equity in Malaysia.
Before we proceed to the cases, we would like to explain how common law and equity are applied in Malaysia. The reason that the common law and equity can be applied in Malaysia is because of Section 3, 5, and 6 of Civil Law Act 1956. In Section 3, it is stated that Malaysia can apply U.K. common law, rules of equity and certain statutes with the conditions that there is lacuna in our law, distinct circumstances in the country and the following common law, rules of equity and certain statute applied as before the cutoff date. To add on, the cutoff date differ from Peninsular Malaysia, Sabah and Sarawak. As for Section 5, it is stated that English law on commercial matters can be applied in Malaysia as long as it fulfills the conditions as stated in Section 3. However, for Sabah, Sarawak, Penang and Malacca, they need to apply the latest law as England. Meanwhile, Peninsular Malaysia, except Penang and Malacca, has cut-off date which is April 7th. 1956. At last, Section 6 of Civil Law Act states that no UK common law, rules of equity and certain statutes can be applied in land matters in Malaysia.
Now let us continue to the cases. In the case of CAS and MPPL and another, the plaintiff, a pilot, claimed to be the biological father of a child born to first defendant, a stewardess, during her marriage to second defendant, also a pilot. He alleged a sexual relationship with the first defendant from 2005 to 2014 and sought a DNA test in 2015 to prove paternity. The first defendant had admitted to the relationship but denied that they had sexual intercourse during the likely conception period. The plaintiff had presented evidence of his involvement with the child through photos and videos. The issue of this case is whether the High Court, in exercising its inherent jurisdiction as parens patriae, had power to order a child to carry out DNA tests to identify its paternity. The High Court held that in exercising its inherent jurisdiction as parens patriae had power to order a child to carry out DNA tests to identify its paternity. Furthermore, for the ratio decidendi of this decision, in re Spence in 1847, the judgment held by Lord Cottenham LC and which was also applied by Lord Denning after 120 years in the case of Re L and BBR and BJ, the common law of England on April 7, 1956 authorized the courts as parens patriae to issue any order that are suitable for the greatest interest and welfare of a child. There are presently no written laws in Malaysia governing the power of the courts to order a DNA test on children in civil proceedings. Thus, it follows that there are no written laws in force in Malaysia that has modified, therefore applied the common law of England on this issue under Section 3 sub 1 of the Civil Law Act. Besides, the stare decisis of this decision is the case of Tony Puakayam v. Government of Malaysia and another appeal, in which the federal court held that common law is law as long as it continues to be enforceable, and that the mechanism for deciding of whether it continues to be enforceable lies in Section 3 sub 1 of Civil Law Act. Last but not least, the overall judgment of this case is that either the first defendant and or the second defendant shall bring child to the hospital within 7 days from the service of the order on the first defendant and or the second defendant to enable the hospital to take all the necessary steps to obtain specimens, by intimate or non-intimate means as decided by a medical professional at the hospital, from the child and the plaintiff in order for a DNA test be carried out to identify the child's paternity in relation to the plaintiff.
Next is the case of PT Karya Summit in Indonesia and Ocean Masters Marine Services Senjal Berhad and another. The brief facts of this case is that the plaintiff, KSI, claimed against Ocean Masters and Sapphire Line for the loss of copper rods valued at $5.91 million shipped from Jakarta to Dammam under 3 house bills of lading. The cargo was released at Dammam without the required original bills of lading, bypassing payment by the buyer, Jawad and Malik Metal LLC, JMM. Instead, the switch bills issued by Super Express Cargo enabled delivery to JMM's customer, Alphaner Electrical Systems. KSI alleged breach of contract, duty of care as bailee, conversion, and conspiracy to injure, seeking damages. The issue of the case is whether plaintiff had locus standi to bring action. The court held that the plaintiff didn't have locus standi to bring this action against Ocean Masters and Sapphire Line. The ratio decidendi of the decision is that the court applied Section 1 and 2 of the Bills of Lading Act 1855 for this issue, in which both are applicable in Malaysia according to S5 of the Civil Law Act due to absence of local authorities. Pursuant to S2 of Bills of Lading Act, the shipper has right to sue the ship owner for breach. The court concluded on a consideration of the entirety of the facts that property and the goods did not pass to JMM. The totality of the factual evidence suggests that the defendants would be suspected on breach of contract. Thus, KSI clearly has locus standi to sue defendants for breach of contract. Not just that, the overall judgment of this case is that KSI has succeeded in establishing its claim against both the defendants on a balance of probabilities, and accordingly judgment in the sum of $5,914,010.40 with interest from October 5th, 2012 is entered against Ocean Masters as prayed for in the statement of claim. KSI is also entitled to the costs of this action from Ocean Masters in the sum of 80,000 ringgit Malaysia only.
Lastly is the case of Peter Chong and Ainer and Khatija BT MD Ibrahim and Ainer, personal representative of Aisha BT Ibrahim, the deceased, in another suit. This case concerns a land in Georgetown, Penang, sold in 1940 to Mohammed Ibrahim, whose daughters Aisha and Khatija later became joint proprietors under the National Land Code, Penang and Malacca Titles, Act 1963, after he passed away. Aisha unilaterally sold parts of the land in 1990 but died in 1998 before completing the transfers, leaving Khatija as the only proprietor of the land. The plaintiffs sought specific performance of the agreements, but the High Court dismissed their suits. On appeal, a retrial was ordered to determine if the land gift as joint tenancy was bound by the Islamic law, in which also recognized as the Mohammedan law. Furthermore, the issue argued in this case is whether English common law principle of alienation re prefertur jure accrescendi on severance of joint tenancy can be applied in this case. For this issue, the court held that the English common law principle of alienation re prefertur jure accrescendi on severance of joint tenancy cannot be applied in this case. Taking note of Section 5 Sub 2 of the Civil Law Ordinance, it is held that the English law principle on severance of joint tenancy relief by plaintiffs cannot be applied due to the reason that this principle was not incorporated in Civil Law Ordinance. This position continues to be unimpaired by Section 6 of Civil Law Act, in which lays down that English law that are involving land matters cannot be applied in Malaysia. So, for the overall judgment, he claims of the plaintiff against first defendant was dismissed.
For conclusion, the application of common law and equity in Malaysia, as governed by Sections 3, 5, and 6 of the Civil Law Act 1956, reflects the continued relevance of English legal principles in the Malaysian legal framework. Each section specifies the extent to which English common law and equity principles can be applied in civil, commercial, and maritime matters, respectively, subject to any modifications by local statutes or circumstances. This is especially after the analysis of the relevant cases, as these cases underscore the judiciary's role in ensuring the alignment of English common law principles with Malaysian law, balancing the historical influence of English law with the country's evolving legal landscape. Therefore, while English law continues to supplement Malaysian law, its application is tailored to suit the local context and statutory framework.
Capybara, 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 capybara. Capybara. Capybara, 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 capybara. Capybara. Capybara, 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 capybara. Capybara. Capybara, 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 capybara.